distinguished delegates, ladies and gentlemen, on this 10th anniversary of the resolution commemorating Mother Earth Day, we will now begin the first panel discussion of the 9th interactive dialogue of the General Assembly on Harmony with Nature. During this panel and ensuing dialogue, we will discuss the theme Education in Harmony with Nature. Before we begin, I would like to acknowledge the presence in today's audience of elders from the HwN nation who are currently articulating a Mother Earth approach, a traditional Mother Earth approach in the contemporary language of rights of nature, as well as a Maori elder who is a direct descendant of one of the only 3 women signatories of the Treaty of Waitangi. I would also like to acknowledge a number of professors, researchers, and postgraduate candidates from Yale, Harvard, Columbia, and New York universities, as well as St. Francis College, a number of Brazilian universities, and many more currently following the broadcast all around the globe. I want to acknowledge the entire audience, as well as all those who are following us remotely. Finally, I want to extend our warm greetings to His Excellency Minister Edison Fachin of the Federal Supreme Court of Brazil, Her Excellency Minister Justice Teresa de Assis Moura of the National High Court of Brazil, along with His Excellency Justice Agustin Grijalva of the Constitutional Court of Ecuador, and Dr. Cristian Derani, professor at the Federal University of Santa Catarina in Brazil, who are celebrating this day with a contemporaneous dialogue on harmony with nature at the Center of Judicial Studies. Among other topics, they will be addressing the court's role in acting in harmony with nature, as well as the role of language and semantic plurality and diversity within this emerging discourse. Although we were not able to connect due to different time zones, we would like to extend our warm wishes to them. My name is Dr. Alessandro Pelizzon, and I am a legal scholar from Southern Cross University in Australia. My scholarship has focused over the last decade on the emergence of what I, together with a number of colleagues, have termed an ecological jurisprudence. And it's thus a great honor for me to be here today, to participate in what is certainly a vital program, and to introduce today's wonderful panelists. In 1972, Professor Christopher Stone of the University of Southern California concluded what is now a very famous property law lecture with what was then, and still is today, a very provocative question. Should trees have standing, he asked. The question had been prompted by a proposed development in the Mineral Valley of the southern Sierra Mountains of California, which would have destroyed an old-growth forest. The Sierra Club launched an action to stop the development. However, the Supreme Court, Justice Douglas dissenting, argued that the plaintiff wasn't directly damaged by the proposed development and therefore didn't have any standing. However, Professor Stone counter-argued that something was indeed damaged, the old-growth forest, and therefore if standing was necessary to stop the damage, then maybe standing ought to be extended to the forest itself. What, we may ask, makes that damage legally invisible, or at the very least legally irrelevant? Some scholars point to the transition from a hunting-gathering society to a settled agricultural society, which began roughly 35,000 years ago and culminated 10,000 years ago with the Neolithic agricultural revolution. Other scholars trace this back to a particular worldview known as deterministic materialism. And according to mathematical cosmologist Brian Swim, deterministic materialism is comprised of 3 tenets. Quote, that all things in the universe are composed of tiny particles of matter, that these particles are purely material without any degree of subjectivity, and that these particles move according to fixed mathematical laws. End of quote. The roots of this particular worldview are certainly found in the oldest philosophical texts we possess. The pre-Socratic philosophers were concerned with the investigation of the nature of matter itself. Is matter a single substance capable of multiple expressions, or is it a collection of separate parts? The most famous answer that we still possess today is that of Democritus, who argued that nature is comprised, and matter is comprised of distinct, separate, and ultimately independent particles he called atoms, floating in a void of nothingness. This was then combined with, 2,000 years later, with Cartesian dualism. Descartes famously created or introduced the distinction between the mind, or res cogitans, and matter, or res extensa, and the mind being possessed of exclusively by humans. Coupled with the rise of industrial technologies, this coalesced into a particular set of legal structures that, ever since, have categorized the non-human world, that is, the entirety of the cosmos, as objects, in particular, as objects of rights, and in particular, as objects of property rights. And if the subjects of those rights hold absolute dominion over that which is the object of those rights, then indeed, the destruction of an old-growth forest is legally invisible. And it is against this backdrop that Professor Stone asked this question. The question was further articulated almost 30 years later by eco-theologian Thomas Berry and South African environmental lawyer Cormac Cullinan, who argue that humans are members of an interconnected and interdependent system of beings and phenomena, and that the well-being of all members of this system is connected to and dependent from the well-being of the system as a whole. Therefore, the protection of the system as a whole is paramount to the very survival of its very members. They thus proposed what they called an earth jurisprudence, a theory of law capable of acknowledging such human interconnectedness and inextricability from the rest of the world. The consequence, the direct consequence of this, was casting the non-human world, or nature, as a legal subject. And this began in 2006 here in the United States through the work of the Community Environmental Legal Defense Fund in Tamaqua Borough in Pennsylvania. It was further expanded with the constitutional provisions of Ecuador, of the new Constitution of Ecuador of 2008. It was then articulated in the Universal Declaration on the Rights of Mother Earth, not the shift from an impersonal definition of nature, signed in Cochabamba in Bolivia in 2010. The two legislative initiatives of Bolivia of 2010 and 2012 were then followed by the launch of the Harmony with Nature program. In New Zealand, the Te Urewara Act of 2014 and the Whanganui River Act of 2017 are two more recent bills that identified elements of nature as legal persons. The cases of the Atrato River and the Amazonian case of Colombia, the Uttarakhand High Court of India discussed the Ganges and Yamuna case, as well as the glacier case. These are just some of the examples of an idea that is spreading incredibly fast over the last 10 years. The speed at which things have progressed suggests that, to paraphrase Victor Hugo, this may very well be an idea whose time has come. With this in mind, I'd like to open the first of today's session.